Good afternoon, officer or detective?
Officer Adam, no us.
No, I apologize. If at any point in time the question is confusing, please let me know. I'll try to rephrase for you, okay?
Okay.
I want to start with the fact that before you responded to the scene, everything you knew about the dispatch was based on what somebody else told you, correct?
That's generally how radio affects.
That's the answer to my question.
Yes.
So you were at the police station at the beginning when you received the call?
I was at the end of my shift.
So you were on patrol in that neighborhood already when you received the dispatch, correct? You yourself were driving in the neighborhood and saw somebody dead or something that looked suspicious and you stopped the car before you stopped the person and spoke with them, right?
Correct.
So I want to talk about the point in time. So when you received the dispatch, was it just a dispatch of the allegation that somebody called in, or was there any description that was also released?
The initial dispatch call was that a neighbor observed a man person carrying items out of his neighbor's garage. He was still on the phone with dispatch, and dispatch advised that they observed him loading items into a vehicle and then the vehicle to caller gave a description on that woman, dark blue license.
Okay. So you eventually made the scene, correct?
We were en route to the scene when we observed the vehicle in question.
And were you by yourself in the SWAT car, or were you
That's the part.
with a partner? What was your partner's name?
Corporal Matthew Van.
And when you enter the neighborhood, you say that you see one of the only other car that's leaving is it a cul-de-sac kind of neighborhood or?
It's a very long, straight road with multiple cul-de-sacs on it. There's only one way in and one way home.
Okay, and then at that point in time you saw a car.
Coming towards us.
And that's when you were actually driving in the other direction, the opposite direction, correct? And then you kind of did a little U-turn and turned on your lights.
Correct. I quickly turned around. Actually, the lights.
And once you turned on your lights, you didn't turn on the side yourself, right?
I did not.
But that person stopped their car, right?
It is.
They didn't continue driving or they were right. And then once you approached the car, your testimony that he had his license didn't handle it, right? And that person, when you made contact with them, they weren't wearing a mask, correct?
Correct.
You can see their face. He was wearing a sweater, I believe. It was like a
Swearing on, I believe it was more like a plaid shirt at that point.
a plaid shirt. And at some point in time, you say that you looked into the rear of the car and you saw what you said to be a generator, right?
Correct.
And that's because the call that you got was for a home invasion, right?
Correct.
And before you had made that stop to speak with Mr. Arnold, Mr. Arnold, you didn't stop at the house that called saying that our generator's missing, somebody took it, right?
That was what was related to the dispatch. I didn't get that.
So you didn't go speak with the victim that said that their generator was.
Not up to that point.
So you don't know if that was the actual thing generator. At that point in time, you never saw a picture of what that generator was before you saw the generator in the back of Mr. Arnold's car.
Didn't know it was a specific generator. I just knew that it was a yellow generator. In the back of the vehicle to start.
That's fair. And before you stopped that vehicle and you saw the generator, you actually don't know how that generator got into the car, do you?
No.
So you weren't like following, you didn't follow that car, or you weren't. What's the word?
Counsel, he said he didn't know. Let's move on.
Okay. You asked the person that's sitting in the driver's seat to settle, correct?
Correct.
And he complied with all of your requests and demands, right?
Never asking why I didn't stop. Correct.
He didn't pull away from you and detain him and put handcuffs on him?
No.
Okay. And before making that arrest, you did not get a chance to watch the every camera footage, did you?
No,
At what point in time did you actually watch the every camera?
approximately an hour later, I made the location of alleged meeting.
And the time that you stopped the car that Mr. Arnold was in, you don't see him walking around on the sidewalks of the house, trying to open car doors, do you?
No, it's right.
He's driving, you don't see him walk.
Counsel, you're wasting time. You're wasting time. The record's been made. He's testified to all that.
I didn't observe.
He's testified. He was driving one way, the car was coming the other way, he did a traffic stop, and that's where he met Mr. Arnold. So obviously, he didn't see him walking down the street. He saw him driving a car.
I understand this.
Then move on. Move on.
So, it's your testimony that you searched the car, correct?
I did.
And you searched the bags or the cross item?
I searched every storage of that car.
And the thing, and like the containers, correct?
Yes.
And in that cross body bag, that's where you say you found items that were reported missing, correct?
I'm sorry, what was the last part?
That were reported missing.
In the rear portion of the car, there was a large amount of tools. And initially, what was reported missing was the jetter.
So you had no idea about headphones or change that had been reported?
No.
I'm gonna object, Judge. How's that relevant?
What's the relevance?
The charge that he's charged with is recording the headphone. And
Well, it's relevant that they were in his possession, but it's not relevant whether or not he was looking for them when he stopped and went through the car.
then
How's that relevant?
same fact and circumstance that provided him the problem of that was necessary to stop Mr. Arnold is not even the charges that Mr. Arnold is brought against for today, but he had the opportunity.
It doesn't matter. It doesn't matter. Counsel, he could have been dispatched to a shooting in progress and stopped a car that matched the description and found contraband that had nothing to do with the shooting. That's not relevant. They can't only arrest people for the charge they're going to investigate. Move on.
There's no identifying information related to Mr. Arnold that he found in that bag that he searched, correct?
No.
No further questions.
Anything else?
Nothing, not.
Smart move. You can step down, officer. Thank you. Do the people have any other witnesses today?
Judge, the only other witness would be, in regards to Officer Berry, who can essentially testify. As an offer of proof would be him testifying as to the photos that he took of the.
If you want to make another stab to get him in, you better lay some more foundation.
I understand. Yep, we'll call Officer Berry then. And it'll be very brief, Judge.
Officer, come on up. Raise your right hand, swear, affirm, tell the truth, the whole truth, nothing but the truth today.
I do.
Come on up, watch your step on my ramp, settle in the chair. Proceed, Mr. Muhammad.
Officer Berry, can you just state your full name for the record?
Yeah, Ryan Berry.
Officer Berry, are you currently employed?
Yes, I am.
What's your employer?
Van Buren Township Police.
And what capacity are you employed there?
Police officer, day shift.
Okay. Were you employed in that capacity as a police officer on October 19th, 2024?
Yes, I will.
Okay. And you worked that day by yourself or the department?
By myself.
Okay. Did your duties on that day at some point take you to the Belleville Police Department?
Yes, I did.
Okay. And while you were at that location, what did you do?
I was investigating a larceny from auto complaint. And I understand that they had some property that was recovered from a vehicle where someone was taken into custody. So I wanted to review what property had been taken.
Okay.
And not turned over already to victims.
Okay. And was one of those locations that you were investigating 45270 Sunrise
Yes,
in Van Buren Township?
correct.
Okay. And do you recall what the items were that you took photos of?
Yeah, there was well, there was a handful, there was a lot of change, from Mr. Minus vehicle. Rough estimate, anywhere from $20 to $50 in quarters, mixed change. He also had, two phone chargers, they were DeWalt phone chargers, I don't think it was red, I'm sorry, black and yellow phone chargers.
Were there additional items that you took photos of?
For Mr. Midas' house?
No, at the Belleville.
Oh, yeah, I took some photos of a digital camouflage bag, and a pair of headphones.
Thank you.
Wasn't reviewed lately.
I've handed you what's been marked as People's Proposed Exhibit number 2, 3, 4, and 5. Let's start with number 2. Do you recognize it?
I do,
How do you recognize it?
photograph this,
You what?
photographed it,
Okay.
yeah,
And does that appear to be a fair and accurate depiction of the items that you took photo of?
yes,
Does it appear to be altered or manipulated in any way?
no,
Okay, Judge, the people would move into evidence, proposed exhibit number 2.
Ms. Farage. That'll come in.
And what is it exactly?
it looks like a hat or a sea mask and a pair of gloves.
Okay, Judge, I'd like to publish the report.
Sure.
And how about, people's proposed exhibit number 3? Do you recognize it?
It was a sweatshirt that I found in the property,
Okay, and did you take that photo of what property?
of the property that I photographed at Belleville City Police.
Okay, and, is that a fair and accurate depiction?
Yes,
Does it appear to be altered or manipulated in any way?
no,
Okay. The people would move into evidence, people's proposed exhibit number 3.
Ms. Farage.
Objection.
Thank you. That'll
I'd
come
like
in.
to draw your attention to people's proposed exhibit number 4. Do you recognize it?
I do.
How do you recognize it?
It was a single strap backpack that was also in the evidence area at Belleville City Police Department.
Okay, and is that a photo that you took?
Yes,
Does it appear to be altered or manipulated in any way?
no,
Is it a fair and accurate representation of the bag that you took photo of?
yes,
Okay. Judge, people would move into evidence. People's proposed exhibit number 4.
Ms. Farage.
Objection.
That'll come in.
And the last one, sir, I'd like to draw your attention to people's proposed exhibit number 5. Do you recognize it?
I do.
And how do you recognize it?
I took this photograph at Belleville City Police Department.
And what is it?
A pair of headphones, nail clipper, looks like a marijuana grinders.
Okay, and does that photo appear to be a fair and accurate depiction of the photo you took?
Yes,
Okay, does it appear to be altered or manipulated in any way?
no,
Okay, Judge, the people would move into evidence. People's proposed exhibit number 5.
Ms. Farage. Thank you.
I'd request the public.
You're welcome.
Open the
Counsel, cross.
Good afternoon,
Absolutely.
Officer Barry.
Yes, ma'am.
At any point in time, I should use the real knowledge and let's do it.
Okay.
So you just, how did you come in contact with the evidence?
Earlier that morning, well, I'll start from the beginning. Belleville City Police is dispatched through our dispatch on the same radio channel. Earlier that morning while I was in roll call, I understand that they were sent on a home invasion within their jurisdiction, where they had taken a male into custody and located a lot of stolen property. So when I started to get the call for the larceny from auto from Mr. Midas' house, I didn't exactly know at that point that this could be connected, but I started to work to see if I could find any suspect information or any cameras, and I did an area canvas.
And were you able to locate any cameras?
I got a camera from Mr. Peterson's home, some video clips that he provided me. And then Miss O'Neill, later in the day, while I was doing an area canvas in the neighborhood, I was notified by Lieutenant Abdullah that she had also been a victim of a larceny from auto, either that night or earlier that morning. So when I made contact with her, I was able to get some video clip from her as well.
Okay, that's great. So speaking about Miss O'Neill, you had a chance to speak with her, correct?
Yes,
And she was able to describe to you what she believed was taken out of her vehicle.
you're right.
And is, your honor, if you'd like to.
No.
Thank you.
Whatever one you need.
Thank you. Permission to approach the witness, yeah?
Sure.
I'm showing you what has been identified as People's Exhibit 5. It's your testimony today that you took that photo, correct?
Mhm.
And when you spoke with Ms. O'Neill, she had an opportunity to describe the headphones that she lost, right?
Correct.
She described them as the ones that are being like over the head.
Yes.
Those are not really,
Those
those are not those headphones, correct?
Correct.
Thank you, Your Honor. He said that these are not the headphones that were described.
I got you.
Now, have you, I know that, Belleville and Van Buren Township work together, correct?
Correct.
So were you involved with the arrest or detainment or search of Mr. Arnold's personal property?
No.
So at what point in time did you have possession of whatever was collected off of Mr. Arnold and to have an opportunity to photograph?
I'm sorry, say it again. When I had possession of it?
Yeah, so those photos weren't taken on the scene, were they?
No, that was at the Belleville City Police Department.
Okay,
Yeah.
so did like all the evidence come in like a box and you just kind of like put them on?
No, Belleville City Police stores all their property, in their Sally Port, in a gated area in Sally Port. Thinking that this may be connected down the road, or if I were able to get some additional, victims, I went to their station and photographed that in the station.
Okay, so before you had, did the photographs, did you have an opportunity to review any of the camera footage associated with any of the break-ins in the area?
I saw, no, I did not. No video camera.
So it's all you know, so you're just looking photos of the whole
Yes,
time?
As part of my investigation.
Mr. Mohammed, any further questions for this officer?
So can I see those exhibits? I'm sorry?
There's no question that's been asked, so I have to.
Yeah, ask a question.
So people's proposed exhibit number 5, whose headphones are those?
Couldn't tell you.
Okay, did you learn whether or not, did you provide the victim with her headphones?
I did.
Okay, can you describe those headphones?
Yeah, they're the,
Hold on, just clarification. Describe the ones that you gave back to Miss O'Neill.
yes.
Thank you.
Yes. They're a one-piece headphone. They're the ones that wrap around your neck and have that band that holds on. And then the headphones go in your ear, like for people who are working out, not the earbud type headphones.
Okay, did you take a photo of those headphones?
Yes.
Okay. And where did you get those headphones from, the ones that you recovered and provided to the victim?
In the evidence box that they had in the Sally Port of Belleville City Police Department.
Okay. And did you provide those photos, what did you do with those photos that you took a photo
I
of?
uploaded those to the evidence server along with my case report.
Understood.
Yep.
It's not really here. It's not really on file. And where you got those from Belleville Police Department?
Yes,
In relation to this case?
yes, from, the property, from the person that Belleville Police had custody.
Understood.
Yes.
And no further question.
Ms. Farage.
Based on that, we got the.
Okay, thank you. Officer Barry, you can step down.
Thank you.
So I got it. I've been thinking about it.
What's
I'll
up?
call it Connie. Were you hunting a swamp?
What's that?
Were you hunting a swamp? It had to be.
But, no further witness.
Thank you.
All right, Ms. Farage, any witnesses or are we ready for argument?
No one is so I haven't.
I'm ready for it.
Move for a bind over. Whether or not that photo number 5 doesn't change anything. The fact of the matter is the officer indicated that he recovered headphones and provided them to the witness, and she indicated, clearly details of what those headphones were. So I just want to get ahead of that. I understand there must have been other headphones that were recovered, and it's just those are introduced into evidence is what we have. I'm going to reserve my argument.
That's fine.
I just wanted to get ahead of that.
Ms. Farage.
Your Honor, we ask that the court not bind over Mr. Arnold on the charges. First part of my argument, according to Michigan Court Rules of Criminal Procedure 6.110, the preliminary examination subsection probable cause, it requires that the prosecution, even in a probable cause standard, must prove that not only that an offense was committed, but that it was defined. Mr. Arnold was the person that committed this offense.
No, that's not true, counsel. Not true. They don't have to prove that he was the person that committed it. That's trial.
Court finds probable cause to believe that the defendant has committed an offense found by the district court and must proceed.
Probable cause. You said the people have to prove that he did it. And I said, that's for trial. And we'll talk off the record, but it's offensive to me that you're going to stand there and tell me how to do probable cause hearings after 26 years on the bench. So I don't need you to explain what my job is today. You can make the arguments about how he didn't meet his burden, but please don't stand there and tell me how to do a PC. So move on.
I had not meant no offense to the court when I was.
Oh, I didn't think you meant it, but I found it. I don't think you meant to offend me.
Okay, so
I'm just telling you that it is offensive. So just move on.
there has been no testimony today of eyewitness identification. All of the 4 witnesses that have testified here today by the prosecution state that it was in fact the person on the ring camera video footage was the person that's sitting here before the court as Mr. Arnold. In fact, the first 3 civilian witnesses testified to not seeing the person's face. Your Honor was able to see one of the exhibits that was admitted by the government to prove that the person's face was in fact covered.
Counsel, take your time.
Moving on to the criminal jury instructions of breaking and entering. Again, Your Honor, this is a specific intent crime according to the criminal jury instructions. There has been no specific intent that has been shown or demonstrated by any of the prosecution's witnesses as well as their exhibit to show that it was Mr. Arnold's intent to take the things that were described by the people whose homes or cars were broken into. Again, nobody saw his face. Nobody came in contact with the person. At the time the officers made an arrest of Mr. Arnold, he was nowhere near one of the cars or the homes that were listed as the incident locations. Nobody testified to hearing his voice. There was none of the evidence that the officers testified to finding in the car that Mr. Arnold was driving can tell us exactly how those items had ended up in those cars. They weren't following Mr. Arnold. They weren't surveilling him. They just made a turn, stopped him. None of those things were found on Mr. Arnold's person. He was searched. There was no testimony today to suggest that Mr. Arnold was caught with ski mask on, with the jacket on, with the duffel bag across his chest as depicted by the video discovery that was introduced by the prosecution. And Your Honor, we ask the court not bind over Mr. Arnold due to the prosecution's inability of proving the identity of the person or the charged offense.
Thank you, counsel.
A courtroom explodes into chaos as a defense attorney boldly challenges the prosecution, only to be instantly shut down by the judge in a jaw-dropping exchange. Police insist the suspect was caught with stolen property, but the defense fires back, claiming there's no eyewitness, no clear identification, and no direct proof linking him to the crimes. Then the judge snaps with a brutal warning, "Don't tell me how to do my job." As the courtroom falls silent, the entire case hangs on a razor's edge. Is this a shocking wrongful arrest, or a criminal moments away from being exposed?
Mr. Muhammad.
Judge, as this court is very well aware, all we have to show is a question of fact for the trier of fact. I believe the testimony does reflect that. We're not here arguing guilt, we're here just arguing whether or not there's a question of fact. And, you know, the defendant was pulled over and he had in his possession a mask which was referenced.
Mr. Muhammad.
I understand.
I might have given you the impression that I fell asleep up here today, but I didn't.
I understand.
So I've been listening.
I understand. And Judge, I would just argue that there's a question of fact for the trier of fact, and I think all the factors that were listed already on the record, in the totality of the circumstances reflect probable cause. Move for a by mover, that's hard.
Thank you. Thank you both. I agree, it's a probable cause standard. I believe that it has been met by the people. I will bind over. AOI date is going to be December 4 at 9 a.m. Bond will be continued. We'll get Mr. Arnold a paper notice to that effect. We don't do that anymore. I keep forgetting.
Thank you.
But I wish you luck downtown, Mr. Arnold. Ms. Farage, come on up.
I'm sorry.
Come on up.
Thank you.
You're welcome. What do you got, Ms. Mandernack?
Judge, we have Randy Callis.
Tallis? What are we doing?
That is a good question.
Okay.
We need your infinite wisdom to help us.
Punt.
Judge, parts is a plea.
Okay. Parts?
Ready as well, the defendant, the president.
That's correct, Your Honor. What's the story later?
Okay, so hold on. Let's get the file. People versus Ryan Parks appearances.
Hey,
good afternoon, Your Honor. Neighborhood Defender Service by John 151. On behalf of Ms. Ryan Parks.
Okay. We're bringing her out in just a minute.
Thank you.
You want to wait until she's out here to say anything more?
Yeah, we have a
Okay.
fleet and
Okay.
regarding potential sentencing.
So this is going to be basically 3 misdemeanors instead of 3 felonies.
Oh my God.
Ryan.
Ryan.
He stepped out.
Ryan,
Ryan Young.
I'll yell at him when he comes in here. I don't even know. I'm like, damn young kids.
So I could state
Go ahead,
them
go ahead.
orally.
All right. So what there's a sentencing recommendation. What's going on?
no, yeah, that's the question. They're giving 3 misdemeanors, attempted joyriding, to use instead of possession. My question, so by way of background, she is currently serving 1 year in the county jail for an Oakland County fleeing and eluding and receiving concealing.
Okay.
Her discharge date release date is May of 2025. My only question, this comes with a spree of other incidents related to heroin addiction. And so she's more than willing to do probation. Get to the question. Is the court able to indicate whether it would give no more than like 6 months in the county jail as part of this disposition so that it doesn't
Like jail at all.
Oh, okay.
I'd rather have her in treatment programs.
Yeah, and that's what she wants.
How do we
can't get out until May.
I'll see some of them.
So she won't get out until May, but she can
Schedule
program
sentencing in May.
in May. Okay. That's fine.
I defer.
You don't care when I sentence.
I defer to you. You know more.
No, I'd rather get her out of, where's she at?
She's she's here, but
No, I mean-
she's serving for Oakland County.
I'd rather get her out of, get that done and come in here and let's get her in a treatment program. That'll give you a lot of time to figure a program out.
Fine. Yeah, that works. Perfect.
All right, People versus Parks appearances, please.
Good afternoon, Your Honor. Mohammed on behalf of people P86771.
Good afternoon, Your Honor. Neighborhood Defender Service by Jonathan Cohen, DA 6151, appearing on behalf of Ms. Ryan Parks, present in custody. Can you state your name?
Ryan Burns.
Thank you. All right, guys, put the deal on the record.
So Judge, my understanding based off of my discussions with the OIC and the officers involved is they approved the plea in this case, which is reducing the both possession counts to use and the receiving, concealing would be reduced to joyriding, attempt, one.
Attempt joyriding, right? Correct, counsel?
That's correct, Your Honor. And that's our understanding that each of those would be a 1 year maximum in 2 years.
All right, Ms. Parks, do you understand your rights and options after discussing those with counsel? You understand the possible penalty for these 3 charges? Understanding all of that, are you pleading guilty freely and voluntarily today to the added charges? Counsel, would you voir dire and get me the facts I need for a November 21, 23 incident date?
Yes, November 21, 2023, Ms. Parks, were you, grab mine.
What do you want to know? Location? Van Buren Township.
Yeah, were you located at approximately 10915 Belleville in Van Buren Township? Were you in possession of a vehicle at that time? Did that vehicle belong to you? Did you take that vehicle without authority from the owner?
Yes.
But did you intend to return the vehicle?
Yeah.
Did you also use on that date time fentanyl? Did you also use cocaine?
Gentlemen, you satisfied? So am I. I'll dismiss the original counts 1, 2, and 3. So do you have an actual out date from Oakland yet?
May 5th.
May 5th? Are you in any kind of a treatment program now? There?
And a.
All right. All right, so here's what I'm going to do. I've accepted your plea on these charges. I'm just making a note in the file. We're going to sentence you after May 5. So keep in contact with him. If you get out early or something like that, get a hold of him. He'll get you in here so I can sentence you. He's going to work on a treatment program because I want you in treatment. I don't want to put you in jail yet. I want you in treatment. All right. So in the meantime, I'll put you on a personal bond on these. So that means if they release you and you don't come in here, now you violated my bond. Understood? Or if you get into new charges after you get out of there. So raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond? Counsel, is that all clear enough?
It is, Judge. I was going to ask the court to keep her on and have on so she'd be approving credits concurrent, but I understand the court.
I don't want her to.
I understand.
Because if I'm going to send her to treatment, I want to hammer over your head to make sure you're going to treatment.
Understood, Judge.
Normally I'm pretty good about that stuff. The other thing is we've got a file here that you owe us money on from 2015. I'm closing that and giving you some Oakland County jail time credit and just close it out. All right? I'm giving you a lot of grace today. So seriously, if they cut you out early, get in here so we can get you into a program. All right, good luck. Ready on Talus?
Yes,
Oh, Heather.
Yeah, thank you.
Appearances for Talus, please.
the people, P8408.
But these questions, I don't make a I'm going to my left.
Good afternoon.
Good afternoon, Mr. Talus. You can have a seat. What do we got?
Judge, we have discussed this at length, and as I previously indicated, we have some preliminary matters that we need to.
What are they?
So, Your Honor, I guess some things, but first is that, I have requested of the people, to provide what I would call a statement that was made by the complainant, about this case. I believe it's a signed statement, it's a signed written statement, and I believe it to be potentially exculpatory and also certainly useful for impeachment. It's my understanding that the people the people as a whole are refusing to do that. So that's the first issue.
Well, let's take them one at a time.
It's kind of tied together. I am also asking the court to consider adjourning this matter because it's my understanding that either way the people intend to proceed via hearsay, via the domestic violence hearsay rule. I did not anticipate that in any way in this case, and I would ask the court, in addition with the issue of the statement, I would ask the court to consider a brief adjournment of the matter. There are some issues that, as we move forward, I would like to address as it relates to bond, as it relates to that as well.
All right, why would you not want him to have the statement?
Judge, maybe approach,
Well, better question, why would he not be entitled to the statement?
judge, maybe approach,
Sure.
and then we'll make a record of conversation.
All 1,000. Go around.
Yeah.
Okay. Just one.
Well, I think this language right here, she talks about the role, it just says. So I'm gonna order her to stay in Judge.
Judge. And can I request a protective order for it?
Sure.
Okay.
Yeah.
That's.
All right, so we're back on the record with the Tallis matter. I have reviewed the report in question, and I do believe it's something that defense should be entitled to, and I will order release to Mr. Bickert with a protective order, so it's for Mr. Bickert's eyes and Mr. Tallis's eyes only. Agreed?
Yes, thank you, Your Honor.
Any more clarification necessary?
No, Your Honor.
Not as to that issue.
All right. Now, as to the adjournment.
I'm asking the adjournment, I'm asking the court to consider, an adjournment. I was not aware of this statement, so today.
That's problematic.
Asking the court to consider a brief adjournment and prepare for the evening.
I have no objection.
I do. I hate adjournments. December 23, December 30, or January 8.
I asked for the soonest possible day, Your Honor, which leads kind of into the next.
That's December 23. What time, Heather? 1 o'clock, December 23.
That's fine.
I'm sorry, December 23rd?
Yep,
Which is a Monday?
yep. Unless you want to be here on 25th, which my family would not appreciate it.
Yeah, that's what hesitation I has. I think my family might appreciate the 23rd. But I will
It's
take
your option, 23rd or 30th.
both there, figure it out.
All right, so we're going to talk bond next.
Yes, Your Honor.
I believe the bond is 20,000 personal, cannot return to the Houston address, no contact with Erica Buchanan, and no alcohol or drugs. Are we all on the same page with what the current conditions are?
Yes, sir.
Go ahead.
Your Honor, we're not asking for, a change in any of those numbers or anything. What the situation is, and I apologize, Your Honor, no. And Mr. Tallis is not at his home because of the no contact. It is my understanding, I believe there's some car operation that is that, this is kind of a difficult situation, but there's another person, there's a break-in, in essence, or at least a destruction of property.
I wouldn't say break-in, I think the
That's fine.
allegation was brick was possibly broken.
Okay,
And that's why I was changing, or possibly a malicious destruction situation. Either way, a window was broken out at my client's home. I don't know who it was, I don't know who it was there, et cetera, et cetera. He has no contact, he has children at the home. Brick was, at least my understanding.
get to the ask.
I'm sorry. And I know it's a difficult situation, but my client is asking if there's any possible way that he could return home. I understand that is a huge request in a case like this. However,
Let me stop you right there. Is Miss Buchanan here?
she's not, I don't believe so.
The only way I'd consider is if I could talk to her. That's the only way I'll consider. I'll make myself available. We'll try to do something on Zoom if we need to. After I'm sure she's talked to the victim's advocate and she tells me that she wants him to be able to come home, then I'll consider changing the bond.
What would be the best way for me to get that hurt?
Talk to Heather.
Understood. Thank you.
Anything else?
No, Your Honor.
Goodbye.
Well, I'm sorry, Judge, did we have the time for the exam on the 23rd?
1 o'clock.
Thank you.
All right.
People already understand.
I'm sorry, Stanley?
Yes.
All right. Appearances, please.
Mohammed Abraham. He is.
Oh, hold on. That's Mr. Bickards. Go, that's all right.
Good. Yes.
Thank you,
Sorry about this.
Appearance on Stanley.
You have Mr. Stan. Should be in your Zoom room.
No, he should be here. It's a live exam.
Fair enough. That's absolutely true, Your Honor.
He's not
And
there.
he called me. He called me and I apologize, Your Honor, but he was the one that was literally just sending that ID to.
Okay.
He called, indicated that he thought he was supposed to be on Zoom. I know how that part works. I indicated that it's not.
Hold on. I got to cut you off. Was that 2 hours ago that somebody told him he was supposed to be here live? Because you and I had this conversation earlier today.
1:30. Yeah.
1:30. It's 3:20 and he lives in Romulus. He could have literally walked there by now.
We discussed that because I asked, I said, it doesn't sound like with that, because he said, look, I have no right. I said, sir, where are you at? I couldn't leave. Or as I may have actually been to get. It sounded like he was too far to walk, but again, I understand what the court is saying.
Too far for a lazy ass to walk.
I understand what the court is saying. I did ask Mr. Stanley to stay, to kind of stay put and stay by the phone, because at the time, Your Honor, and I will admit this was an hour ago, but there was an ongoing exam. I couldn't ask the court, and I couldn't ask Mr. Muhammad, and so I just told.
This ain't on you, Mr.
I understand that, so I told him to hang tight. So that's
He
where we're
didn't
at.
do that.
That's
So you can tell him I'm issuing a bench warrant today.
that's where we're at. And that's that, Your Honor. Can I walk Mr. Stanley in?
Sure.
Do we need to do that on an exam day, or can that be any?
Any day he wants to get the warrant off his back,
Oh,
because there's a warrant on his back.
I anticipate that the court will see Mr. Stanley very, very soon.
Good, because I've got a few things I'd like to share with him.
Understand. So with that being said, Your Honor,
Have a nice day. You can tell him it's a 10,000 cash. Are you ready, Mr. Jones?
Of course, Judge.
A simple custody hearing turned into one of the courtroom's most emotional moments. The judge's final warning wasn't aimed at winning or losing, it was about an innocent child paying the price for her parents' endless conflict. Instead of choosing sides, the court chose to protect the child's future, delivering a powerful lesson every parent should hear. If you enjoy real courtroom stories with unforgettable verdicts and life-changing moments, subscribe to The Legal Lens for more shocking legal cases every week.